All right, thanks everyone for joining us for today's webinar, Family Law Q&A, with special guest speaker, family law attorney Sandy Wakim. As usual, these webinars are presented from the perspective of an accountant, an estate planning attorney, a financial advisor. Today's webinar is presented by Yuri Yu. She is a certified public accountant, and her office is located in Fullerton, California. Donna Lee is a certified financial planner, and her office is located in the city of Orange. And Sophia Kim Sakamoto, an estate planning, probate, and living trust attorney with offices in Buena Park and Mission Viejo. If you do have any questions, please type them in the chat box below. We will answer them at the end of the webinar, time permitting. Please note this webinar is being recorded. And just some disclaimer information, of course, we're not giving any specific legal advice, right? There's no attorney-client relationship formed and everything's copyrighted. So if you do need to take a screenshot or if you want to use some of the material, please let us know beforehand.
Hi, so I'm excited to introduce to you our guest speaker today. Her name is Sandy Wakim, and she's an attorney with Nordhoff Bengfort. They're a boutique family law firm based in Newport Beach. Sandy has dedicated her career exclusively to family law. Her approach ensures that clients are able to identify their goals and how they relate to the law. Sandy understands the importance of active listening, something that's very important in this area. And so in order to achieve her clients' objectives and establishing a strategy that is unique to their individual needs. She recognizes that zealous advocacy is a non-negotiable aspect in family law. While in law school, Sandy was a member of the Trial Advocacy Honors Board, Alternative Dispute Resolution Program, and completed an externship with the OC Public Defender's Office. Sandy, thank you so much for joining us today. I'm really excited for today's webinar.
Thank you. Thank you for having me.
All right, great. Well, let's just get right into it. And as you know, we collected these questions from our clients and we hear them so often. So we wanted Sandy to come as the expert to kind of talk about community property and other issues with family law. So getting right into it, what's the difference between community and separate property and why does it matter?
Right, thank you, Sophia. So a lot of you may have heard or may not know, but California is considered a community property state. What does that mean exactly? So there's two prongs here. There's separate property and community property. Separate property are assets or debts that are acquired before the marriage or after the date of separation, meaning after you have separated from your spouse. There are exceptions to that as well, and I'll get in touch with that later. Community property are assets or debts that are acquired and or incurred during the marriage. And community property is essentially property that is divided by your spouse equally. So generally everything that you and your spouse acquire during the marriage, for example, if you purchased a vehicle during the marriage with the income you earned during the marriage, that vehicle would be considered community property and generally speaking would be divided. Now, separate property includes inheritance that you may receive during the marriage or a gift that you may receive during the marriage. So I've always recommended clients, and you should, even if you're not getting a divorce, if you do receive an inheritance or a gift, to make sure that it's separate and not intermingled. The reason being, in the event of a dissolution, it would be very difficult to prove that is your separate. You would have to kind of trace back, oh, this gift of $100,000 I received during the marriage is actually mine. You know, when we do discuss the dividing things, which kind of brings us to the question of why does this matter? It matters because this takes a huge effect as to how to divide property at the time of the dissolution of a marriage. So it's always good practice that when you receive inheritance, perhaps have it on a separate account or keep very good records as to when you received the inheritance, how much it was, where it was deposited to, and how it's used. Because remember, if you're using that inheritance to purchase a home, then that plays a huge role when it comes to dividing a home, which I'll get to touch later on. So all of these, the definition of community and separate property are general. There are exceptions, and there are very complex issues that relates to the division of property when it comes to dissolution.
Sandy, I get this question where, I'm going over the assets with my clients and they're married and like, oh, this bank account's in my husband's name, this one's in my name. So they put it as separate. What do you think about that?
So title never matters. So if you open a bank account in your name during the marriage, that is considered community property. Income is considered community property. So whatever you're earning during the marriage is yours. So most people may have joint bank accounts and you have income and you're putting in the joint bank account, that income is considered community. If you have your own account in your own name and you're putting your income in there, that's still community because it's income earned during the marriage. So
Yes.
Title doesn't really matter as a presumption. Same with credit cards. Debt that you incur during the marriage, even if it's in one spouse's name, would be the responsibility of both spouses. So it's very important thing to learn, to be cognizant of, especially if some spouses may have, like to go shopping. Know that at the time of divorce, you may be responsible for that debt. However, at the time of separation, which is the date of separation, is always very contentious in a divorce, because it's that point in time where everything you earn now is yours and everything that your spouse incurs is theirs. So if you file for divorce and there's a date of separation established, doesn't give you the right to go out and take your spouse's credit card and go on a shopping spree, because you may end up being responsible for everything that you purchase.
That's a good point. I also want to say it does matter if you were to pass away and you don't have like a trust or will, the way that community and separate property is distributed is different. So for example, you had community property and you didn't have a will or anything like that. If you pass, 100% goes to spouse, but separate property would be divided if you have more than 2 kids, 1/3 to spouse, 2/3 to your kids. So the way that it matters at death also is important.
Yeah, and when it comes to taxes, just to jump in here, this is one of the reasons why if you live in a community property state like California, if you want your filing status as a married couple, most of the time filing jointly is the best status. I get that question a lot from clients that are getting married. We're getting married, should we file jointly or separately? And I say almost always jointly, unless there's a very specific reason that you want to file separately. This is because, like Sandy said, all the income that you earn is, both of yours. And so when you file separately in a community property state, you don't file like I report my income, they report their income. You actually combine your income and then you split it 50-50. And so it's administratively, it's a little complicated because the IRS uses tax forms to make sure that your returns are complete. And so if you're reporting income from someone else on your return, it just kind of makes things a little complicated. So most of the time though, it is almost always best for tax purposes to file jointly. You'll pay less tax that way.
Sandy, let me just clarify when you say that title doesn't really matter. So a lot of times families will come and they have a trust set up because they want their, the beneficiaries to be distributed a certain way. And then they get a inheritance, let's say. They can keep that as a separate property and still title it as a trust, correct?
Correct. So yeah, inheritance is one of those exceptions to the rule, even if you receive the inheritance during marriage, is that it is your separate property, as long as you keep good tracing. That's very important, because sometimes people say, oh, this amount was from my inheritance. Well, can you
Prove it.
trace that? Yeah, you can't just say it. So it's just very important to kind of keep good documentation.
Yeah. And this is it could be as simple as just creating another account, a separate account, like a different account number.
Yes, as simple as that.
Yeah.
Awesome. And so then my next question is, okay, well, does everything become community once I get married? And people always ask me, well, what about that one 401k that I had before marriage? What happens to that?
Yeah, so as I mentioned, community property is anything acquired during that period that you're married. So as soon as you get married and you went and bought a house, presumptively, that would be your community property asset. As far as 401ks, so again, most people may have 401ks through their employer, and they may have had that before they got married. And then you get married, and then you start, again, income is community property as soon as you get married, and you start contributing, you know, your 401k, maybe you have a deduction, your employer matches, whatever how it is. That contribution towards the 401k is now community. So presumptively, that half of that you contributed is your spouse's, should you dissolve the marriage. So that's considered a community property interest in the 401k. So if the 401k you had before marriage, like I said, and you did not contribute to it, then that would, and you know, you haven't touched it since you've been married, you're getting to the point where you're dissolving the marriage, then presumptively that would be your separate property. You established it before the marriage, there was no contribution of your income towards it, you left it alone for whatever reason, then generally speaking, that would be awarded to you as your separate property. Again, so with residences, I may be touching on that later, but same kind of similar thing. If you bought the home before the marriage and then you got married, you're contributing to the home and by way of a mortgage, that interest then at that point is your spouse's community interest. However, that equity that you're establishing in that residence presumptively is community at the time, even though you purchased the home before the marriage. So there's certain calculations that we, you know, do to make sure to determine what is actually community interest. It can get very complicated when spouse refinances it or if there's a loan in their name, but generally speaking, the home would be to have community property interest is what we would say.
Good to know. What then, if you have some assets that you had before marriage and you wanted to protect them, what are some options or what can few clients do?
Right, so some people may have had a home they bought before the marriage, titled in their name, and they got married, and maybe they don't want to have to split that community property interest in their equity. Best thing to do is really a prenuptial agreement where you clearly outline what is it that I want to keep my separate property despite the California laws. So what is a prenup? Prenup is essentially a written contract between two parties before they got married. It's very important that this is signed prior to the marriage. There are some rules where as to how far in advance this should be prepared and written and signed to ensure the validity of the agreement, and there's no issues as to somebody feeling like they've been tricked or pressured to signing it in order to get married. So best practice is at least before you send out wedding invitations. So generally it's maybe 3 months before the marriage, but I would definitely bring that up at least a year in advance so you're not, you know, stressing out your spouse, and later down the line they may say, oh, I just felt like I had to do it or I was not going to get married. But prenups is a way to go against what the default rule is. So it's similar to an estate plan. You want to say this is the law, but this is what I want it to look like, within reason, of course. You can limit spousal support. So generally speaking, I'll touch on this later, but if you want spousal support to be a specific amount for a specific duration, you can include that in a prenup. If you want certain assets that you've acquired before the marriage to remain separate property despite being married, then we can list it that way. Businesses are a huge thing. When you get married, depending on the type of business you have, you may end up having to split that with your spouse, even if they don't work for the business. So a lot of people get prenups for that reason, to ensure that it's considered separate no matter what, and the spouse can't touch it. A lot of them, if you work for a law firm or accountancy firm, they really like having those, so you don't have to deal with kind of having to split some of that interest in that business, and it protects the sanctity of the business as well. So I know it's not the most romantic document, but it actually encourages people to talk about their finances and I think that's very important, and it's a huge part of being married is sharing those finances and the responsibility. So the best thing is to talk to your estate planning attorney if you have a split estate plan, and prenuptial agreements in order to protect those assets.
Yeah, and just to kind of add to that, from an estate planning perspective, sometimes we do a separate property trust for a client for their separate property assets. So if they pass away, maybe they don't want that asset to go to their spouse. Maybe they want it to keep it on their side of the family. So that's something we can do to protect that separate property asset. We could also include a separate property in a family or a joint trust. You simply label it as separate, and when it goes into the joint trust, it's still considered separate, and the way that it's passed down could be a little bit different, but there's ways to do that as well.
Yeah.
Sandy, I have a question.
Yeah, go ahead.
So this is important to note that we're really talking about, because we all live in California. I don't know if all of our guests are in California, but this is a big distinction between community property versus separate property. What happens if a client moves from a community property estate to a separate property estate, or vice versa? What happens to those assets? How do they?
Yes.
What are they? How are they considered?
So this is a new term. It's called quasi community property. So if there's property that was acquired either by one or both the spouses when living in another state during the marriage, it would be, so in California, it would be considered community property. If it was in another state, it would be considered something called quasi community property. So when that happens in a divorce or legal separation in California, if you're getting divorced in California, that property would then be considered community. I can't speak to how the other states will divide it. Should it be a marriage in California and then they later move to a different state, then it would be, they're at the mercy of the other state as to how they handle certain assets that are acquired in California. But if it was you got married in another state, you have to establish residency in California. But once you meet the residential requirements in order to get divorced in California, then property that's acquired in another state during the marriage would be considered what we call quasi community property, and it will be treated as if it was a community property.
So it's really based on the time of when you file for divorce, where your residency is based off of.
Yeah, so sometimes you may want to consider, there's a lot of disputes sometimes with some spouses, trying to get divorced in a different state. Each state they have their own resident requirements, and you would at least have to establish that you've been married. You can be married in a different state, but at least that you've been living in the county where you're filing for 3 months and 6 months of residency in California in order to file in California. So there can be disputes there. You have to show that you live here, you have a home here, you're paying rent here, you work here, you've been a resident of California. Maybe you file tax returns, I don't know. You have a utility bill showing that you are a resident of California in order to properly file in the state.
Okay, thank you.
Mm-hmm.
And so I know that you kind of touched on this a little bit earlier, but what is spousal or child support? I know that there's a lot of misconceptions or confusion surrounding those terms.
Yeah, so spousal support is essentially payment by one spouse to another spouse after the parties separate. So it can be you can be ordered to pay it even before the divorce is finalized. This would be called temporary spousal support. Generally, it's a little bit more, you're going to be required to pay a little bit more than what you would be ordered to pay for permanent. The reason being is usually you're still kind of conducting discovery, and so you want to get some support to the other spouse who may not have worked during the marriage, just to get those temporary orders in place while the divorce is finalizing. It ends up equalizing in the end if one spouse does overpay, but spousal support is calculated by the length of the marriage and earning capacity and income of the parties. And length of marriage is important because it really plays into the fact as to how long you're entitled to pay or entitled to earn it. In California, a long-term marriage is considered to be 10 years. So if you're in a marriage for less than 10 years, then spousal support, the duration, generally speaking, would be half the length of the marriage. And then if you're in a long-term marriage, which is 10 years or more, you would be entitled to spousal support, or you would be paying spousal support for what we call for permanent duration, meaning until one spouse remarries, once the spouses die, and or further order of the court. What does that mean? Sometimes there may be issues that come up that requires you to modify support. Maybe one spouse is not remarried, but cohabitating. What is cohabitating meaning? They're residing with a significant other. There's a presumption if you're residing with a significant other, means that you're probably getting support from that person and you may not need spousal support. So that you're maybe entitled to modification at that point. Maybe one person wants to retire, or somebody lost their job, they can't afford spousal support anymore. So you can go back to court and ask them to consider a modification of your current support order. And child support is payment by one parent to the other on behalf of the child. So the child doesn't receive the money, the parent receives the money under the presumption that they're going to be paying for the basic necessities of the child. So that would be like clothing, food, housing. Doesn't really include daycare and all that. So people usually come to an agreement as to how they want to handle daycare or schooling and tuition. So child support is not necessarily encompasses those items. How you determine child support is based on timeshare, and again, earning capacity or income of the parents. Timeshare is how much time the child is spending with each parent. So the parents have a 50-50 schedule and they earn maybe similar amount. Child support may be nothing or very minimal, depending on the income of the parents. If the child's spending time with one person more than the other parent, then likely that parent that doesn't see the child as much will be paying more in support, because that parent who's with the child is spending on the child pretty much. So there's something called a disomaster, which is what our office used to determine the calculations for spousal or child support. The court also uses the same program. So you would put the information in there, such as what's the income of each party, what is the timeshare, meaning for the children, deductions are included. So if you're paying healthcare, we would include those numbers. And then once you'll receive a number, and that would be considered the guideline amount. So we kind of get an idea as to how much the one parent should be paying the other. Sometimes we can be flexible, and with that guideline number, it kind of helps when it comes to settlement purposes, like this is the number that I should be receiving. And we can be creative in that regard. And that's
what kind of information is used to figure out how much spousal support is? Yeah,
so it can get complex. So let's put a scenario out there. There's one spouse. He was the breadwinner. I'm going to say husband was the breadwinner. Wife was what we call an out spouse. What that means is she may have been in charge of the household, may have been, her focus was on the children, and therefore she wasn't working for a significant period of time while she was caring for domestic duties. At that point, to determine spousal support, we would look at her earning capacity, right? So how much is she able to earn? Should she become self-supportive? Maybe she has a degree in marketing, and when she got married and had children, she stopped working for a period of time. So the court would consider that. What is reasonable amount of time for her to go back to work? Maybe it's been several years, maybe it's been 10 years that she's had a job. So obviously it's not reasonable for her to go back and get a job at her earning capacity. Things have changed. She may need to go back to school, take some refresher courses. So in order to determine what is her true earning capacity, we do use third-party experts sometimes. We'll have like a vocational evaluation done if there's a huge dispute as to wife's ability to earn or husband's ability to earn. It goes both ways. But just in this example, let's say we can use a vocational evaluator who looks at her resume, where she worked previously, how long it's been, what's the market industry looking like right now, and they kind of give a consensus as to, okay, I think wife will have ability to earn $60,000 a year. Should she return to school, or so on and so forth? So it kind of gives us a ballpark as to how to provide income for that spouse as to what her earning capacity is.
Oh, yeah, that's very interesting and good to know. And I think you mentioned that you can include some of that language beforehand in a prenuptial agreement.
Yeah, so if you're, so you can limit that. I've seen people put that you would not get spousal support, just depending, or you would be entitled to spousal support only if we have a child. You can't talk about child support in a prenup. So the only thing, you're not limited to childbearing issues. That's all a no on a prenup, but you can say that should our marriage be longer than 10 years, then your spousal support will be a lump sum payment of X amount. You could limit spousal support saying, despite the length of the marriage, I would be paying spousal support for half the length of the marriage, or whoever. So you can get pretty creative with that when it comes to prenups. Just kind of, at least if you cannot control child support, if you can't control child custody, you can at least control what your assets are and how much you would pay in support and spousal support.
Very important. Okay, so then what happens if you do get a divorce? Well, what happens to your assets like your house or retirement accounts?
Right, so I think I touched the house a little bit, but these items, generally speaking, would be divided during divorce. If the items were acquired during the marriage, the home, generally speaking, you have some options, right? So maybe one person wants to keep the home because the kids are there, they don't want to cause so much disruption. If they're able to, they can refinance the home so the other spouse can be removed, and that spouse would have to buy out the other person. If that's not financially feasible, then the other option would have to be to sell the home and the proceeds would be divided. I mentioned that if the house was purchased before the marriage, there may be some little bit financial calculations needs to kind of go into place to see how much, if that person who bought the house before the marriage wants to keep the house and they're claiming that house as my separate, then we would have to divide the equity in the house, whatever that may be. And that would be kind of the buyout for that. And usually the spouse, I mean, I've seen it either way. Sometimes the spouse buys it before the marriage, but it never puts the other party on title, or the party signs an interspousal grant deed. So that would be easier because the spouse is already on title. So all they would do is just buy her out of, or him out of the equity. Retirement accounts are similar. Generally, they'd be divided. Whatever the interest, whatever that you contributed into the account during the marriage would be divided. So we generally would have somebody called a quadro attorney kind of determine that calculation for us. They'll take that retirement account, they'll determine what is the community interest in it and how it's going to be split. So if it was an IRA, sometimes they will roll it over for the other spouse, whatever that interest is, they'll roll it over to whatever, if they have an existing account. But I always recommend to my clients to speak to their financial advisor or CPA to determine tax consequences when they're dividing these kinds of accounts. Just because, and quadro attorneys are not cheap, so you want to make sure it makes sense to your individual case. So if sometimes both spouses have their own retirement accounts, if they're quite similar in amount, we can just settle and say everyone keeps their own, so we don't deal with the division. Doesn't really make sense financially. Other assets like furniture, I always recommend do not talk to your attorney about that. Divide that on your own. I'm sure it's not worth the amount you're paying your attorney to deal with it. So worst case, our rule is garage sale value if you want to split those. Otherwise, highly recommend splitting those on your own. Vehicles, generally, whoever uses that vehicle during the marriage would kind of be awarded it. If it's a lease, then they would refinance accordingly. If it's bought, then we may split it based on the fair market value. So maybe somebody's vehicle is worth more than the other, and that's the vehicle they use. We'll kind of equalize it towards the end of the divorce if they were awarded that vehicle. Otherwise, pretty sure that in bank accounts, same thing. Joint accounts, we would either divide what's in the joint account, and then they would close that account. If it's the account in their own name, we would determine how much is in that account. Depending on how much is in your bank account, I would always recommend everyone keeps their own account. It always gets equalized towards the end. So if one person's keeps the account, they have $15,000 in, and the other person has $500 in, we would have to equalize that without having to just close accounts when it's already in your name. But again, this is all determined based on the separation date. So whatever you earned after and you put in your bank account, we would not consider that sum.
Just to talk about houses, when there is a divorce and one spouse is buying out the other spouse, so one person wants to stay in the house, that buyout payment does not change basis in the property. So if you bought the property together for $500,000, now it's worth $1 million. One spouse gives the other $250 to buy them out. That your basis is not $750. Your basis is still $500.
Right.
Now, if you turn around and sell it for $1 million, when you're now single, your capital gain exclusion is now only $250 instead of $500. So you're gonna pay tax, capital gains tax on $250. The math is a little funny, but it's just something I wanted to mention because it's not really intuitive. You would think that if you were paying someone out for your own home that it would increase your basis, but it actually doesn't.
So maybe it's better to, maybe it's better or cleaner to sell it when you're not divorced yet, right? So
I always recommend if they, to sell the house. A lot of people think, oh, I can afford it, and then they can't, and then it becomes complicated later. So the house is, generally speaking, one of the largest assets in a divorce. So it's always, of course, the most disputed. Knowing that you have a house, I always try to, hey, what do you want to do with the house? Let's kind of deal with it in the beginning. Also, it gives the parties some money that they'll need later to finalize their divorce, and it kind of helps financially speaking.
And I was just going to say, you should also update your estate planning documents and beneficiaries. Don't forget that. Yuri, weren't you going to mention something about taxable assets when deciding?
Oh yeah, that's just something else to kind of consider when you are splitting assets. There are some assets like retirement accounts. There's pre-tax retirement accounts. There's after-tax retirement accounts. And so kind of just taking into the the tax side of whatever asset you're getting. So if you're getting you might not split assets 50-50 based on the value today, because maybe later when you take distributions from those retirement accounts, you're going to have to pay tax on it. So it's not really worth as much as the balances in the account. So it's just one of those things to kind of consider when you are splitting assets. And
Okay, great. So then, of course, if for those who may be thinking, okay, well, should I get a divorce? I mean, what kind of steps do you usually counsel your clients if they're coming to you for advice before anything happens?
Right. So I always recommend to educate yourself, plan accordingly. So if you are thinking about it, I would try to get your finances in order. It's important because once you file that petition for divorce, there's something called an automatic temporary restraining order in effect that freezes everything. So you can't change your beneficiaries. You can't sell your house without consent of the other spouse. You can't take the children out of the state. You can't move things around. You can't do anything basically without the consent of the other parties. So if you're kind of considering it, try to keep that in mind and plan things accordingly prior to that filing that petition. So I always recommend speaking to your financial advisor, your estate planning attorney, your CPA, a therapist. I think it's really important to know for sure, is this what I want? It's also important to kind of have that therapist with you while you're going through the process. It's difficult. It's probably the most difficult thing you're going through, and it's highly tumultuous, and you don't want to spend that time, your attorney's bills, to be on your emotional issues when they are not, we can't do that. So we want you to be emotionally well. So I always recommend speaking to the therapist on that. And you want to determine how are you going to pay for an attorney. So kind of planning that budget in advance. Usually an out spouse or somebody who may not have the funds to pay for an attorney, you can get attorney's fees later, but it's always important to know, how am I going to pay for it before we get to that point? So having a budget in place, itemize and inventory your items. What do I have? What's valuable to me? What do I think is mine, and what do I want? Have an inventory of those things. When you move out, you may not be able to get everything that you need from the residence if you're the one moving out from the family residence. So just making sure you have an inventory of what it is that the house has, so that you can later divide it amongst yourselves. And then also write out your story. You're going to use the story with several people. So you want to tell your attorney, this is my divorce story. This is what I'm going through. This is the facts of the case. Because that's going to save you some time and also get you organized, and make it efficient. Sometimes there may be several issues in the case that you're not aware of. That's very important, especially if you have children. How do you want to plan things out for your child? This is super disruptive to them when two parents are leaving a residence. So it's important to have that kind of schedule in place. What kind of schedule do you want for the kids? How does this affect them? If you're moving out of the residence, who's taking the kids to school? So writing out that story in advance before speaking to an attorney, and you may want to speak to several before you're finding that right person, would definitely help them issue spot some things for you. And every case is different. You can get very creative. There are creative strategies. Not all divorces need to be so crazy and messy. So find the right person for you and making sure that you're definitely ready to do it.
Sandy, this is obviously a very emotional process. So, what if before I file the petition, I'm just like, I'm going to take all the money out of my bank account. Do I have like a duty to my spouse?
Yeah, so there is fiduciary duty. They're considered like your business partner. So what you can do is take half of whatever that's in the bank account because that's entitled to you, but you cannot take the full thing out. That is a violation of your fiduciary duty to your spouse. And that may cause some problems later down the line in court, and you may have to pay them 100% of that instead of just 50 because you have that duty to not hide things or hide assets. It's important not to hide assets. There's the disclosure process during a divorce where you go, this is what I have, and this is what I think it should be awarded to. Or you can be like, oh, it's my inheritance, it's my separate. It's important not to hide anything because if we later kind of find it, that can generally be awarded to the other spouse. So 100% of it, no matter what its current price of.
Oh, all right.
Yeah.
Well, thanks so much. Now we're at the time for questions. Do we have any questions that we need to talk about?
I have a question from one of my clients actually, who went through a divorce, and they went through the divorce and they asked us for, they had a court order to get it split. And the only thing that's left right now is the house. The problem is one spouse cannot get the other spouse to sign off to sell the house. Even though there's a divorce in place and there's that court order, it's like a separate process, right? To actually practically get that spouse to sign off and sell the house. Is that correct?
Yeah, so worst case, it depends on the facts of that particular case. Sometimes there's a spouse that just doesn't want to be involved in the divorce whatsoever, and their just head is in the sand. You can't get a court order, explain to the judge what the problem is. I need this house sold for whatever reason, or it's in foreclosure, it needs to be sold, and the other spouse is not participating. Then you can go get a court order. It's called ex parte application, which means this is an emergency. I need a hearing date as ASAP, either an order now or a hearing date within a couple weeks, because this is the facts of the case. So there, in California, they don't need both parties to agree to the divorce. It just takes one party who wants a divorce. It may be a little bit more difficult for that one party who wants the divorce and the other one doesn't, but eventually they'll get that divorce, whether or not with or without the other person's input.
Oh, interesting.
That's good to know, because in the movies, it's like, the guy always has to like sign these documents and they like never sign it until the very end or something like that. A question that I get all the time is there common law marriage in California? We've been, me and my boyfriend, we've been together for like 10 years or whatever. Are there any separate property, community property issues? Yeah, so California is not a common law state, but you may still have a claim. It's in the civil part of it's not a family law case at that point. It's a Marvin claim.
is what they call it. So if you're in that situation where you and your partner were living together for 20 years, you're broken up now, maybe you own a house together because you titled it together. There are what's called Marvin claims. So when you speak to a civil attorney, you would kind of ask about that. I have no experience in that as a family law attorney, but just a fun fact for that. But there's no community separate property per se if you're not married.
Yeah, so if you are in a relationship like that where you're not married in California, get some estate planning done for all you single people, okay? All right, is there any more questions, Yuri? No?
No?
Okay.
Okay.
If you do have any other questions, then just let us know by email.
Well, thank you so much, Sandy, for your time and your expertise. I'm sure this was good information for all of our guests today. And of course, thank you to all of our clients who attended. As usual, we strive to provide content that's worthy of your time, and we hope that you find these webinars that we do useful. Reminder that the recording is usually up on the website by the end of the following week, so you can always come back and rewatch areas that you may have missed. So we were thinking back at these webinars, and we actually started these webinars monthly almost 2 years ago when COVID first started, and we wanted to really just stay in touch with our clients and provide you with relevant info. Who knew that 2 years later, we're still doing them every single month? And hopefully, fingers crossed, that the pandemic is starting to, I guess, become an endemic, and things are slowly, hopefully, returning back to normal. And we know that your time is busy as well. So what we're gonna do going forward is we're gonna be having these webinars on a quarterly basis instead of monthly. So our next event is actually going to be in May. It'll be the same thing, the third Friday of May, which is May 20th at 12 o'clock, same time. And we will actually be talking about something that's a very unpopular topic, what to do when a death occurs. So it's not something most people want to talk about ever, and yet it is something that we all go through and experience. And when it happens, that's when we're grasping at straws to figure out what we need to do, or learning, oh, we should have done certain things ahead of time. So no one wants to be in that situation, even though it is something that is, it's not the most fun topic to discuss. We want to make sure that we equipped you guys with the information if and when you need it. So just check back with our websites and such, and we will be having that event in May in 3 months. If you have any questions, feel free to email us ahead of time. We can always try to answer it or answer it at the webinar. So same kind of deal. And then thank you very much again for your time. Everyone will be receiving a survey shortly. So please respond so we know that what improvements we can be made, or what topics you guys would like to hear. We hope everyone stays safe and healthy until we meet again in a few months. So thank you very much for your time, guys.